Hello, everyone, and welcome to today's session.
This meeting is being recorded.
My name is Selin Özbek-Çitone. I'm a managing partner at Özbek Attorney Partnership. It is the pleasure of I have the pleasure of moderating today's session. As Özbek Attorneys Partnership and KP we are hosting a series of panels under the name of KPTalks. This is the sixth one of KPTalks, and today we will be discussing children's rights to privacy in the digital age. Today is a special day for all of us in Turkey because tomorrow is 23rd of April. It's the Children's Day. It was a present from the founder of Republic of Turkey to the children of Turkey and the children of the world. So for us, it is always special to celebrate the Children's Day. In many occasions, you see children sitting in president's office or prime minister's office playing the role of the ruler at the day. They decide on things. So it's always with lots of events, international and national. Obviously today, we will be talking about some aspects of children's rights, but they are very essential because we are at the beginning or in the middle of the digital age. So there are so many things to discuss. I know there are there's audience from different backgrounds, some of them from NGOs, some of them with from legal profession and parents. So we will be touching upon on different subjects with an amazing expert panel today. So I would like to welcome Robert Bond and the FIPIN and Nafiye Yücedağ for today's panel. Maybe you can just introduce yourselves.
Hi, I'm Robert Bond. I'm a lawyer and I'm particularly pleased to be taking part in this today, wearing my hat as company secretary and a trustee of a charity called Southwest Grid for Learning, which I was invited to work with, I would think 10 years or more ago by Professor Andy Phippen, who was then the chairman of the trustees. And Andy and I had got to know each other because back in 2008, I started a pro bono project at my law firm then called the I in Online, I as in information, I as in me, and I as in eyes. And we were looking back 10 years or more ago at how to help children protect themselves online. So here we are talking about exactly the same thing, 10 years or more on. Things are improving, and obviously we'll talk about that in a minute, but that's enough from me. Thank you.
Well, I should add something to that. Obviously, you're being too humble. Well, Robert is one of the leading professionals in the data protection area. He's been listed in various listings as the leading individual or thought leader in the data protection area. It is an amazing opportunity for us to listen to him and Professor Andy Phippen today, together with Nafiye. They will be sharing so much expertise. So thanks again, Robert, for joining us. Professor Andy Phippen.
Hello, everyone. I'm Andy. Coming from the southwest of the UK today. Yeah, I used to say that I've spent about 10 years looking at how young people use digital technologies, but it's closer to 20 now because I'm getting a bit old. I spend some of my life talking to young people about how technology affects their lives, what they wish would change and what they wish would evolve. I spend some of my time in the political area. I spent some of my time in the legal area, which is where I met Robert, and we've worked together ever since. So I guess we're doing something right. We seem to agree on quite a lot of things. Unusually for academics in this area, my background is actually technical. I started off as a computer science PhD many years ago in an AI research lab, which is why it's particularly interesting at the moment where I hear politicians telling me to not worry about this stuff because artificial intelligence is going to sort it all out.
Did we lose Andy? So Dafia, maybe we can.
Yeah, I can take the floor until Andy comes back.
Yeah.
So I work at Istanbul University. So my main field is actually civil law. So in the last couple of years, like 5, 6 maybe, I started to work on the data protection issues. And since I'm a civil lawyer, in essence, so I will today try to explain things from a civil law perspective in relation to the processing of children's data.
Oh, thank you, Nafia. Istanbul University has a special place in my heart as I'm a graduate from Istanbul Law School, and all the lawyers in my family are from Istanbul Law School. So yeah, it is a very unique university with lots of history behind it. So it is a pleasure again to have you here. Andy, we lost you in a minute ago, but
my Wi-Fi decided to try and change to a different Wi-Fi connection for some reason.
Welcome back.
Thank you. If it happens again, don't worry, I will rejoin you as soon as possible.
So you're a digital rights professor at Bournemouth University and a visiting professor at University of Suffolk. And you were talking about what you're doing, but I know you have lots of paper and research on the area. So we will probably be sharing some of the resources that our audience today can follow after our.
Absolutely. I mean, I would say if people do want things that I've written, just send me an email. There's no money in academic publishing, so I'm happy to share things. Don't go buying these books, they're ridiculously expensive. So, but yes, I am happy to share with people who are interested in things.
Thanks a lot. So as I mentioned today, today's session, we will be talking about children's right to privacy in digital age. This is going to be a recorded version of there will be a recorded version of the webinar later on our LinkedIn sites. So you can always watch again and again if you want to go back and elaborate some of the topics. We will be touching about some of the legislative aspects of the matter, but also we will be discussing very practical issues for children, for families, what to do practically, and how can we actually solve the challenges or at least mitigate the risks going forward. So shall I start with Robert with my first question? Robert, what are the regimes in UK and the US protecting children's rights to privacy in general? And what are the differences in your view in UK and US and maybe in EU when we talk about children's rights?
Yeah, thank you. So as you can see from the slide we've got here, at the sort of global level, there has been for many years a United Nations Convention on the Rights of the Child. In Europe, we also have the Convention on Human Rights, which has applicability to children as individuals. Of course, in the EU, we've got the GDPR, the General Data Protection Regulation, which is aimed at protecting personal data. The UK regulator recently published a children's code, which is not a piece of legislation, but is a code of practice, which was the result of a lot of research done about what is helpful for children of different ages in terms of their understanding of what they're doing online, what the platforms are doing with their information, etc. Europe will shortly be finalizing the Digital Services Act and something in parallel called the Digital Markets Act, which again is looking at regulating primarily the big players. And I'm sure Andy will have some thoughts on this as well. In the US, for a good number of years, there has been COPPA, the Children's Online Privacy Protection Act, which was good in its day, but has often not been as well complied with as perhaps it should have been. And indeed, we've not seen enough regulatory intervention in the US where children's data is being inappropriately used or unlawfully used or obtained. We've also got coming through in the UK, off the back of the Children's Code, something called the Online Safety Act, which is not only aimed at children, but is aimed at adults as well and vulnerable persons and so on. And again, we can talk a little bit about that. Just by way of background, I was saying that 10 years, 12 years or more ago, when I started up the Iron Online, and Andy and I worked together on a lot of research. My whole interest in this area was sparked back in 1983. So a long, long time ago, when I was one of the few lawyers back then who was specializing in what we now call computer games law. And a lot of my clients, you know, back in the early days of Sinclair Spectrums and Atari STs and so on, would be going to the shop to buy the game to play on the device. And the games companies, I remember some of my clients, the marketing people going, just look at the data that we've got about not just the parents, but we know because we asked when they were ordering the game, you know, how old is your child and what's your boy's name, etc., etc. Just look at all the stuff we could do with this data. And that was in 1983, when in the UK, we didn't even have a Data Protection Act. And I can remember thinking back then, this would be an interesting area of law to get into. And just literally over the years with, you know, well-known games companies of mine, there have been considerable issues over the volume of data that's collected and then what happens when it is lost control of. And personal data is personal data. And it's interesting when you look at the GDPR, in the EU, we have differing laws about what is a child. In the UK, it's 13, but in other countries, it's 15, in others, it's 16. When you start looking at complying with the law, one of the challenges you've got is how do you give information to children about how they should protect themselves and what their legal rights and remedies are, when what a 13-year-old would be interested in reading is quite different to what a 16-year-old would be, or indeed an 18-year-old. And when we were doing research, Andy and I, back 10 years or more ago, we were going into schools. And I remember in 2012, we went into something like 400 different schools working with other law firms and academics. And we did a survey we got them to look at a simple privacy policy. It was interesting that 2/3 of the teenagers said they never bothered reading the policy. And of the 1/3 that said they read the policy, most of them said we don't understand it. And, you know, here's where we are now, looking at age appropriate ways of presenting the rights. Like most law, the law is always behind the technology. And, you know, Andy will no doubt give some examples of this as well, but we're desperately trying to play catch up. And what I find interesting as a lawyer that's been focusing on this area for many years is, yes, we've got law, but isn't it strange that we have labeling that tells us what the content of food is? We have food labeling.
Yes.
We have labeling around hazardous materials. We have a highway code that tells you where it is safe to cross the road. We still don't have a highway code for the digital highway. And we've been saying for years that, you know, teaching children and indeed their parents and indeed businesses how to manage children's rights and manage the risk for children is still not there. And I guess it will be at some point, but that's actually more than having the law. That's having a moral attitude to the way that you engage with children. And what we don't want to do is to create laws that actually make it impossible to enjoy the benefits of the digital highway.
Exactly. Maybe Andy, before we finish, you have something to add?
Yeah, very much so. I mean, I'm generally in agreement with Robert on most things, and this is certainly no different here. I think the challenge we have is that first of all, you have a range of policymakers who've decided that children need saving. Now, one of the things that I very rarely hear from children is we need saving. They want support and they want education and they want people to do their duty of care, which is a term that we'll come back to again and again. But what they don't want is this passivity around what they do. They are thoroughly enjoying using digital technologies. You know, you go into a primary school and you talk about Roblox or you talk about Minecraft or something, you will not shut them up for hours afterwards. And they don't want measures that are going to make it difficult for them to engage with these services. And I think the challenge we have at the moment, and now if we were doing this 10 years ago, I'd probably be sat here going, platforms are terrible. They don't care about children. They don't do anything. Now these days, I'm generally quite defensive of platforms because it seems to be that the entire policy direction, and the law follows the policy direction, is platforms need to sort out everything. Now, platforms do have massive duties of care around the responsible collection and processing of data, and they have to be very, very mindful of children's rights, but other stakeholders do as well.
Yeah.
I have heard too many times that the safeguarding provisions in data protection legislation mean that we can forget about children's privacy and just access as much as we like and track them and surveil them and monitor them because we need to make sure they're safe. And that becomes quite problematic. Certainly within the UK, one of the things I find interesting is in the domestic abuse legislation, GPS tracking is given as an example of a exacerbating factor and can lead to stronger sentencing. However, you have a whole range of safety tech, which basically said, parents, you should be scared about what your children are doing online. You should track them and then you'll know they're safe. Now, the flaw to that is the one that I speak to parents about a lot of the time, which is you don't know they're safe, you know where their device is. That's a completely different thing. We have a big issue at the moment in that I'm kind of comfortable with where the data protection regulation is at. I think there's some challenges with the age appropriate design code, which we'll come back to, but I think the next generation of legislation, or the next round of legislation, the Online Safety Bill, the Digital Services Act and similar, seems to be placing a huge amount of responsibility with the platforms which the platforms can generally only do stuff with technology. You know, the one I hear a great deal is you need to stop disinformation. Like, okay, can you define disinformation for me, please? But there's a lot of subjective interpretation, those sorts of things. Now, obviously, at the extreme end, and we've come through the pandemic, some people were just sharing stuff which is absolutely crazy. However, some people's disinformation is another person's alternative viewpoint. And when I hear UK politicians talking about how platforms need to stop disinformation, I normally raise the issue that the fact that every single political party in the last UK general election used disinformation to certain degrees to get across their cause. So, you know, if you expect algorithms to do everything, and that's one of the other wonderful things in the policy area at the moment. I hear politicians telling me that algorithms are bad. It's like, are they? Because I just thought they were instructions that someone puts down. Algorithm cannot do anything other than what it is told to do. So when you hear about evil algorithms or mutant algorithms, well, no, that's down to the implementation of the algorithm.
So we'll be talking about maybe in detail about the details of these, but I see from what you tell is, although in UK or in Europe there are more legislations focusing on the matter, still we are not sure whether they serve the purpose. Let's go back to Nafiye and hear about the Turkey. What's in Turkey, Nafiye? Can you give us a little bit of information how Turkey is regulating the rights of children when it comes to privacy?
So we have many provisions, of course, regarding the protection of children under the Children Protection Act, Criminal Code, Civil Procedures Code, and also we have some particular regulations on the publications on the internet and combating crimes. However, when it comes to the privacy of the child, unlike GDPR or national laws like EU member state laws, we don't really have a particular provision regulating the area under our Turkish data protection law. So we do not have a specific age limit set by the code. And the issue is not at all regulated under the data protection law. So when it comes to consent, basically, we have to find another solution to solve this problem. To how we obtain the consent of the child, shall we obtain the consent of the child, or shall we go to the legal representative, or both? So in this case, what we have to do is actually look into the Turkish civil code, and one particular regulation is giving the minor with discernment the right to use her personal data, personal rights, which would include also personal data, to use by themselves. So they don't really need the approval of their legal representatives, and they can just act by their own. So it seems very clear. So the rule seems very clear. If there's a personality right, then minor with discernment can exercise it. But it's not actually that simple, because there's a debate going on, not just for the personal data protection of the children, but in general, so for the personality rights of the children. And the debate is basically, I think, trying to weigh the two values, which is probably the core of the whole issue. So there are two values at stake, and I think these two different approaches are all weighting one compared to the other. So what are these two approaches to these two values? One of them is the protection of child. So, and the other one is the self-determination of the child. So finding the right balance, I think, is not very easy. So the first approach thinks that if the law does not explicitly create an exception, then minors with discernment should be able to exercise their personal rights, personality rights. So, for example, we have exceptions provided explicitly under the Turkish Civil Code, such as marriage. So a person who is 17 years old cannot marry if the legal representative does not allow it. since we don't really have a specific provision regarding the consent of the legal representative of the child, then the child should be able to act alone if she has the discernment. There's another way to look into this. It's not always that simple because especially in online world, that sometimes giving consent, even if the child has discernment, would create a significant actually impact on their personality. And it would maybe create a situation where it is impossible to take back, or very, very difficult to take back, especially considering that once something is on internet, it's going to be always there. So the other approach believes that if the minor would consent to something which would create a significant impact on their personality, then we should seek the consent of the legal representative also. But this would be only in exceptional situations. So I think the first idea is taking the balancing in favor of the self-determination of the child, because the child is also an individual and they have this rights as an adult has also. The second approach is, I think, is going towards more to the way of protection of the children. So I think balancing these two approaches is not easy. And that brings me to another issue. If we apply this to Turkish data protection law, we would have a problem, because this is not a settled issue. And Turkish data protection law is also a law that affects us to decide something, an act is a crime or not. So, or we will give a fine to the data controller. So if you have a rule in civil law, how should we really leave it to interpret it? And if there are two different interpretations, which is opposite of one another, then this would create ambiguity, I think, for data controllers, and this is not something that we want. So from that point of view, I think it would be appropriate to have something, to have a provision under the Turkish data protection law. However, there is also another issue. I'm not sure that the GDPR example is the best way to actually look into it, because GDPR Article 8 states that if the minor is below 16, you need to seek, as a data controller, the consent or approval of the legal representative. So member states can lower it to 13. So this is not unified. The problem here is if you pick 16 years, and if you say, as the lawmaker, okay, if you're below 16 years old, then you cannot consent to anything, but you have to go and seek for the consent of the legal representative. So a minor wouldn't be allowed to act alone. So this actually is a little bit tricky, I think, because if the minor, being at the age of 15, for the particular processing activity, has the discernment, why do we limit, or why do we subject their ability to the consent of their parents, of their legal representatives? So this will a little bit, I think, go against the idea of the self-determination of the child. So I think not picking up an age limit is way better than setting an age limit under the law itself. However, I think like the codes of conduct, such as the Children's Online Privacy Act or Age Appropriate Design Code, could be taken into account, and some codes of conduct for practice could be accepted. That's
Thank you, Nafia. Actually, it's an important point, self-determination rights of children, because you can think about the right to education as a constitutional right for children in Turkey or in many other countries. So sometimes like having access to education can have an important aspect when you compare with the right to privacy. So we will need to balance things. I think we will discuss it in further, but it is an important point. And sometimes with the change of use of internet or digital services by children, these are becoming more and more complicated issues and questions that are hard to answer. So Andy, maybe we can talk about the stakeholders when it comes to children's rights, because Nafia was talking about legal representatives, but legal representatives are actually parents most of the time. And there are, however, many other stakeholders when it comes to children's rights in the digital age. And there are different responsibilities. We talked about some of the responsibilities under the current legislation for companies or for designing of apps and so on. But it's not just that, right? Who are there? What are their responsibilities?
It's a challenging one, because the vast majority of the legislation almost entirely falls in the responsibility of a single stakeholder. If you look at, I always fall back on the UN Convention on the Rights of the Child as my starting point in any of these discussions. You know, most of the world has ratified it, most of the world agrees with it, and then you have politicians and things, you know, completely going against it. I can remember rather brilliantly a UK politician a few years ago saying, as far as keeping it safe concerns, children have no right to privacy. And you go, well, I do think we ratified the UNCRC in 1989, so I'm not sure we agree with that. But if you look at where we're at in the UK at the moment, and this is where I do the vast majority of my empirical work, so I will focus on the UK, there is a great deal of pressure on platforms to show their responsibilities and duty of care. If you look at stakeholders from the perspective of education providers, educators, people will have significant safeguarding responsibility when it comes to children in their care. We have at best some vague direction in terms of you need to teach them about being safe online. And you need to make sure you've got some tools in place to make sure they can't see anything bad online. But that's about as far as it goes. And then the governance structures of schools in the UK is, generally speaking, you have a board, which is generally comprising of volunteers. There aren't many boards in schools where the board membership is paid. So you basically have interested parents, members of the community and things who provide scrutiny to the school. Now, if you look at the statutory guidance in the UK of keeping children safe in education, it specifically says it is the responsibility of the board to ensure that online safety education is delivered appropriately and tools are put in place appropriately. Now, I've done a lot of work with boards of governors. It would be a very unusual day when I meet a governor of a school who has any knowledge in this area at all. So you have this weak foundation, and on top of that you have weak structures, and on top of that you have further weak structures, and there just doesn't seem to be very much guidance at all around it. So you end up with these weird situations. One of my favorite things to do is get into a discussion with a primary school teacher about the digital age of consent and children under the age of 13 going on social media, and it normally starts by primary schools in the UK go up to the age of 11. So I go, do you cover anything about social media and privacy and things? No. Why not? Because they shouldn't be on it. Well, they shouldn't be on it. No, it's illegal for them to be on it. It's illegal for a 12-year-old to be on social media. Is it? What law is that then? Oh, it's safeguarding law. Okay. Is it? Because I'm not aware of that law. Would you? And then you sort of unpick it, and basically what you've got is an education professional who doesn't want to tackle the issues around, because there is a view that if we talk about it, then it will encourage them to do it. But this argument that it is illegal for a child to be on a platform, I find quite amusing. And then you sort of flip it around and go, well, it's illegal for the platform to collect the data on that child. But are you saying you could call the police if that child? And it just seems to be being used as an excuse to not engage in an educational discussion with those children on why privacy is important. One of my other favorite things to do when I'm talking to older children is, is privacy a big deal for you guys? Then no. Generally speaking, they'll go no. Okay, well, why not then? Well, no one's interested in what I've got to say. Oh, no one's interested. Can I look at your phone? No. Well, why not? Because that's private. So, oh, okay. So there are some things, but if they've never had that conversation, they'll never start to think about, well, why am I giving this information and things? And then you get into the really complex, weird discussions where, do you share your passwords with anyone? Well, yes, I share them with my boyfriend or girlfriend. Why? Because we love each other and we trust each other. You know, yeah, but you've just invalidated the terms and conditions. You know, when you signed up to Instagram and you didn't read all those terms and conditions, it says don't share your passwords. But the idea that if you love someone and trust them, you need to have no privacy from them, again, is a really interesting discussion, because it's almost like we don't have these discussions, and then you get into issues in relationships in the future, and they end up in abusive relationships where they're being tracked and where people are accessing, and you end up with horrible situations where after they split up, then they forget that their old partner's got access to their cloud store, and you just get into some really problematic areas there. But generally what happens then when you start talking about those scenarios to politicians is they go, well, the platforms need to stop that, don't they? You go, how exactly? How can you stop? How can a platform stop a 15-year-old giving someone they know their passwords because they don't understand privacy, and they've never had discussions about privacy, and they've never had discussions about the value of their identity? And I think that's really quite problematic. And then you get parents, and parents' knowledge in this area generally comes from the media. And they're told by the media that the internet is bad and evil and it's full of pedophiles and your children are at risk, therefore you need to monitor everything they do. So then parents tell children that they don't have any rights to privacy because and you end up with this mess where you've got all the law focusing towards the platforms and why the hell aren't the platforms doing anything? And you've got virtually no responsibility around other stakeholders. Now, I know Robert talked about highway code for digital services and things a while ago. I struggle a little bit with road safety analogies because the road environment is very stable. You don't come out of your door after a week of not driving and all of a sudden there's 5 different new pieces of technology. But I do think it's a really good analogy in this area. If you've got a parent who sticks their kids in the back of the car and says, right, let's go out for a drive. I've got no idea how to drive this thing, but I trust the manufacturer and they're going to make sure we're safe. And then they crash the car and they're sat there with their injuries going, how did Skoda allow this to happen? That's really weird. Yet there seems to be the entire focus in this area is platforms need to stop all this. Now, as I said, I think platforms do have lots of duties and responsibilities. However, you can't stop a lot of this stuff with algorithms because this is person-to-person behavior. And I think those are the discussions we're not having because they almost fit in the too hard box. It's very easy to get political capital from saying we're going to bring big tech billionaires to heel. They look at them, they're rich and they're taking all your data and they don't care. It's more difficult to say, well, we need to look at society and how society interacts. We need to improve education and build education approaches so we're aware of our behaviors. That's far more difficult, and it doesn't really work in 5-year political cycles, which is kind of where a lot of this legislation comes from.
Thank you. When we talk about stakeholders and what they can or they cannot do actually, shall we explore more what regulations and legislations like the Digital Services and Markets Act or Age-Appropriate Design Code or COPPA require? Maybe Robert, you can give us a little bit of background and more detailed explanation on what we need to do and whether you think this is the way they are drafted is the right approach to the challenges ahead of us.
Sure. I mean, it's both Nathia and Andy have talked about some of the impracticalities or the practical challenges of complying with the law. When you look at, say, GDPR, for example, and in terms of data protection, you've got these EU member states with differing definitions of when a child is entitled to privacy rights or not, and or where you need to get parental consent for the use of a platform. My experience is that from a lawyer's perspective, when you're advising the business, we do what lawyers do, and you draft up documentation and you put in place processes that show that the company did everything it was supposed to do in terms of controlling access, etc., making information available to the 14-year-old, the 15-year-old, whatever. The trouble is that when we do this as lawyers, we advise strictly on what the law requires, and we look at the black and the white. What we're not doing, and what the laws don't really address, is the moral issues and the ethical issues. You know, just because you can doesn't always mean that you should. It's interesting when you look at COPPA and you look at the US approach to data protection or data privacy. The very big difference between the US and Europe is that our laws in Europe are not just about protecting privacy, they are about upholding human rights. We don't see that reference to human rights or human dignity within US law. We may in due course. I think that is something, again, where when we look at children's privacy online, we should be remembering that whatever the legislation says, the business needs to take an ethical position. And recently in the UK, TikTok were significantly investigated by the regulator because their privacy notice said one thing, but what they were doing in practice was something entirely different. Equally, many of the platforms are challenged by regulators on the basis that you couch your guidance or your fair processing statement in language that even an adult can't understand. And just going back to what Andy was saying about my analogy to the highway code, I do think that when we look at complying with, I don't know, the children's code or age-appropriate design, etc., as lawyers, we really do need to think about different ways of presenting the information, so that we should be using more iconography, or we should be using more cartoon characters, something that actually gets the message across and engages with children, so that you've really been innovative in the permissioning. One of the other challenges when you look at things like COPPA or the forthcoming Digital Markets Act and the Online Safety Act is, as Andy said, the way the law is drafted puts all of the onus on the business to be the gatekeeper. And that's an almost impossible task when you find that children are remarkably adept at getting round the so-called gatekeeper, the age verifications, this, that, and the other. That's nothing new. Again, we were looking at this 10 years ago. equally, we're not, in my view, and I said this earlier, we're not engaging with the parents because I find that the children don't quite understand how their data is being used, but they certainly understand how the technology works. And then the problem with the parents is mostly they neither understand how the data is being used, nor do they understand the technology either. Some years ago, again, 10 years ago, I was in a school with a class of 8 to 10-year-old children at the request of the head teacher of the school. And we were showing some videos that had been created by one of the EU regulators, not the UK, but one of the Scandinavian regulators, which demonstrated to children just when things can go wrong and how they can go wrong. And at the back of the classroom was the local member of parliament, who, as he saw this video with some disturbing visuals or suggestions, he said, right, this has to stop. This is inappropriate. We shouldn't be showing this to children, and completely ruined the presentation. And the member of parliament and myself were taken out of the room. I had to hand over to one of my associate lawyers to continue the presentation. And this member of parliament and myself were sat in small chairs designed for children in the headmistress's study. So we were there like naughty school children. And he said, I had to stop that. This is not appropriate for 8-year-olds. And I said, do you have 8-year-old children? And he goes, yes, of course I do. And I said, and do you know what they are looking at online? And he goes, yes, absolutely I do, because we have a computer in the living room. And I said, but don't your children have their own iPhones or devices? Yes. So I said, when they're not with you, do you actually know? And it suddenly dawned on him that he as a parent was not in control. And so I do think that when we look at legislation, we need to also think about education. And that's, you know, across the spectrum. Andy mentioned this, it's educating the people that make the laws. And, you know, it's educating the users of the technology. Having said that, I do think that when you are subject to the law, the more you can do to be moving in the right direction as you follow the law, and by applying morals as well as legal compliance, you are in a better position, even when it still goes wrong. And I know that, you know, that's what the UK Information Commissioner will take into account when things go wrong, is whether or not, as a business, you sought to follow the children's code, or whether you went the extra mile. Again, as lawyers, we draft all of the legal stuff on the assumption that the business then follows it. And we often draft the legal information as if it were a one-time document, whereas in fact it's a living, breathing communication of rights and information. And yet we don't regularly check what is actually happening behind the website, so that for a business, there has to be compliance with marketing, with sales, with IT, you know, with legal, etc., so that you know at any one time what cookie technology are we using to track individuals, what are the mechanisms we are currently using for assessing privacy by design. Do we use data protection impact assessments? When you look at, I'm just looking to the side here, the UK regulator says, I would expect you as a business to protect children from the outset. So you bake in privacy by design or by default, and that you make sure you've got a lawful ground for processing. You need to be very clear when you are marketing to children or you're profiling them, and the way you communicate has to be age appropriate as well. So, you know, I was saying, do you use more iconography or simple language, etc.? And it also suggests that before you launch your new app or your new computer game, you should do an assessment as to what the risks are. And you need to be able to show how you are minimizing those risks. And you probably ought to involve experts to help you assess whether what you are doing is really appropriate for the age group that you are aiming at. And I know we say, you know, 13 or 14 or 15, but there will be, and indeed we do have in the UK, a number of charities that are there for children to engage with when things are not going well. And those can be children, you know, of 6, 7, 8, 9, 10, etc. So again, you've got to think about how on earth do you communicate and engage with a child of 8. That needs somebody who understands the way an 8-year-old thinks and what an 8-year-old is doing. And, you know, that isn't necessarily going to be the lawyer that is drafting the documentation. So the law is great, but how you then interpret the law and you operate as a ethical organization is important, because we do see that when it goes wrong, you can have all those massive fines that we know exist in the law, but what really will damage the business will be the loss of trust and the damage to reputation and the damage to shareholder value.
Exactly. So in that sense, I think the fundamental principles are there, the same principles that we know in heart, but also I think at the core of it, also we need to also pass the test of the best interest of children, whether it is for the best interest of the children or not. So that is an additional maybe test for companies when it comes to children related products or services. That's very important to consider. So Andy, I mean, we've been talking about consent age, and in UK it is 13, and in that will allow children to get engaged freely with internet. On the other hand, we see the Ofcom reports. Ofcom is the UK's communication regulator, and they prepare reports every year, and they often in the reports we see children often struggle to distinguish between information and paid content online. So this is something that we see children struggle to differentiate, and some also argue that if children cannot recognize advertisements, they can also not understand how companies use their personal data. So can we talk about consent being freely given in these cases, and what does that mean? And also from a practical point of view, do you think it is easy for platforms to really determine what age is the child that is using the services, and it is even possible practically based on what actually Robert was saying, that parents cannot always monitor what their children are doing, and children, they always find a way to find a practical way to circumvent things, right?
Yeah, there's lots to talk about there. I'll come on to age verification in a minute because it's one of my favorite rants. So I'll do that in a little while. I would push back a little bit on the question of whether children have capacity to consent, to say that I know a great deal of adults who you might argue equally don't have capacity to consent. You only need to spend a little while on a social media platform to see the utter nonsense that some will constantly share as fact. And it all boils down, essentially. Some of the most mature conversations I've had around this is with young people talking about the fact that we don't need lessons on pornography or sexting or whatever. We need lessons on critical thinking, because if we understand these things from a critical perspective, then we know how to ask questions. And this is where I like where some of the legislation is going, which is if the platform provides the tools, then the user, whether that is a 13-year-old or an 18-year-old or a 50-year-old, understands that these tools are there to disclose concern or disclose harm or make reports of something worrying they've seen. That only comes from effective education. And this goes back to my earlier point that if you have primary school teachers refusing to talk about social media with young people because they shouldn't be on it, and if we talk about it, then they're going to be on it, which it's like, well, you know, they're on it already, don't you? But we need to start young, and we need to look at these things in a critical manner. And, you know, how do you understand that this is paid? Why is this company asking you for all your information, and they want to know when your birthday is and they want to send you a birthday card? Because they want to build pester power, and they want to say when you are, you know, they know how old you are, and they know that you're going to be nagging your parent, those sorts of things. Let's talk about the realities of marketing. And Facebook's free to use and Instagram's free to use. That's because the providers are lovely people, and they just want you to use these services because they just want the world to chat. You know, it's kind of like, that's not a business model. So let's be honest about these sorts of things. But that goes back to another thing that I think platforms could do better, is provide resources that might be able to be used within classroom situations and similar to you know, even if you take one of the more, you know, that I've spent 15 years debating pornography with politicians. It's a great part of my job. But, you know, if you take the education around that and you talk to teenagers about the fact this is a commercial operation and they want you to watch their content because then they can generate ad revenue from it, that starts to become a little less alluring then, doesn't it? Because you're just a pawn in a capitalist machine rather than looking at this content that you've been told you're not allowed to. So why don't we have those conversations? Because it goes back to Robert's experience, a politician deciding that they know best and they've decided they're going to shut this sort of thing down. I spend a lot of time comparing where online safety policy is and where drug policy is. There's a great number of parallels. If you look at where drug policy was in the 80s and 90s, it's right, we need to stop people taking it and we need to shut down the supply routes. That's kind of where we're at with online policy now, is we need to make sure that companies do everything they can, and we need to make sure that children can't look at anything that they shouldn't be able to look at. We need to stop people being nasty to each other, and we need to stop racism. We need to stop all these things. I think I made a note when Robert was speaking where he talked about minimizing the risks. From a company perspective, that's really important, but from a user perspective, I talk a great deal about the responsible end user as well, going back to my example of parent who's never learned to drive, crashing the car and then blaming the car manufacturer for it. If we use words like safety, we're implying we can stop this from happening. Now, you can't. You can mitigate risk, and you can, as companies do more and more these days, they can provide tools if people are concerned to disclose those sorts of things. If we start by saying we need to stop this from happening, we're on a hiding to nothing, because we're not going to do that. But a political message around, we need to understand that these things are complicated and we're probably not going to stamp them out. Therefore, we need progressive education that encourages people to talk about these things, and that education is provided by informed and knowledgeable teachers. It's a far more complex political message than we need to stop this from happening. And you can see if we're locked in these cycles. Now, age verification is a lovely example of this. It's one of my favorite things. If you're talking about even in the age of 18, because we're talking at the moment within the online safety bill, we're going to make all porn providers who are providing porn to users in the UK, they have to put an age gate in place, so that person has to prove they're 18. Now, we do not have a national ID card in the UK, and we don't have any legal requirement for someone to carry a specific age verification token. So you can use a passport, you could use a driving license, you could use a credit card as evidence you're over the age of 18, but none of those are legally required. So even at the age of 18, do we have a way to uniformly have the whole population prove they are 18? No. If you get down to 13,
That's even.
we go, what the hell do you start with that? Are you asking kids to carry their birth certificates the whole time or something? Now, do I think age verification is a useful tool? Yes, absolutely. I'd really rather that kids weren't accessing porn. Do I think it's going to be a perfect solution? No, of course not, which is why I worry when politicians are saying, you need to stop this from happening to platforms, what doing enough looks like. Because as Robert said, the fines are big, the reputational damage is huge. And within the data protection world, there is some means of demonstrating due diligence, if you like. When you're talking about things like age verification, even in the age appropriate design code, they just talk in vague terms about age verification technologies. And then they start to chuck in stuff around artificial intelligence, where an algorithm is going to determine how old you look based upon a training set of other. Yeah, great, but what do you do with the false positives? I was told wonderfully, this is a wonderful discussion a while ago. I don't think I've told you this, Robert, so brace yourself. Within youth football, they sometimes use wrist width, wrist girth, as a way of determining whether someone's under 15 or under 12 or whatever. I was asked a while ago about whether we might be able to look at something like that for an approximation of age verification to access adult services. And I went, so what you're saying is, we're sorry, sir, you can't access this service because your wrist isn't thick enough. That starts to get into really weird places. And artificial intelligence is great at narrow domains where your training data can be comprehensive and you can chuck stuff at it, saying, take a guess at how old somebody is based upon the training data. It's why within UK supermarkets, you have this challenge 25 thing. So you're not allowed to buy alcohol until you're over the age of 18. But that's not where supermarkets are having that challenge. They're saying 25 because guessing whether someone is 17 or 19. Now I have the crushing experience of every time I buy alcohol, the person presses a button saying this person is clearly over the age of 25, because I clearly am. But if you're saying we're going to use AI to do this, you're going to get a lot of false positives. And you have to bear in mind that these are adults trying to access perfectly legal content. So my worry is, if everything is focused on, oh, you lot platforms, you need to sort this out, you need to put your age verification in place, and you go, well, what happens when someone bypasses it?
Yes.
Is that their fault, or is that the fault of the determined irresponsible end user? Or even worse, you drive them down routes like accessing things via the dark web and things where you're far more likely to access dangerous content and stuff. If you're putting all the focus on the platform to ensure this doesn't happen without a mature discussion around what age, I mean, I said to a politician a while ago, age verification in the UK is easy, bring in a national ID card. And they went, we can't do that, it's not British.
Yes.
Well, if you don't have the tokens, then you're always going to be challenged with it. And you could argue that the barriers to entry then would exclude people who aren't wealthy enough to be able to go on holiday and have a passport or drive or whatever. So then you're talking about excluding parts of society, because we're trying to do something where the algorithm can't do it alone. And I think that's the thing I always come back to, is stop saying algorithm when you don't actually understand what it is. I hear it so much. One of our senior politicians apparently visited a very large tech firm a while ago and asked them when they're going to stop using algorithms, because she decided that algorithms are dangerous. And the tech company is sort of going, we can't do a lot without algorithms, I'm afraid. But this focus on the technology can sort everything out is really quite worrying and problematic.
I think for Turkish listeners, it's interesting to know that UK has this very unique approach to ID cards, because you're not required to carry on anyone, and there's a very historical reason for that. We will not be discussing that maybe now, but it is not very usual for Turkish people, because ID cards is part of our lives, and they are from a data protection law perspective, they are heavily processed in almost every stage, and that's been a problem, because they also carry traditionally sensitive data, like sometimes religion and so on. So it's very different for Turkish people to maybe understand the concept of not having an ID card or not being required to carry one, because in Turkey it's totally different. Nafiye, what are your thoughts? I mean, on Turkish law, especially, I would like to hear from you the content, the free content, like we see, especially after the pandemic and lockdown, many families, they had to rely on internet to entertain their children. So that was kind of a unfortunate time that we had to really let children go online more and more. And this is also somehow shown in the Ofcom's reports. And we see even children going online for around 6 hours a day. But mostly the answer of the children, when we see the Ofcom's Online Nation report, is that I only play free to play games, so I don't pay for them. But is that really the case? I mean, do we really not pay for those? I mean, Andy gave some answers already, but I know you have been looking on this in detail, so maybe you can share your thoughts on it too.
Yep, of course. But just before that, I actually, while I was listening Andy and Robert, it's really a difficult issue to balance the responsibility of the parents, who at the end of the day gives the device, gives the internet access to their children, and the responsibility of the platforms, and which means that the data controllers. So it reminds me, actually, the example of pocket money. So if you give your children the pocket money, they're free to do whatever they want with this pocket money. Of course, giving the device to access the internet and providing the internet access as a parent isn't the same as giving the pocket money, but it's a little bit similar. So I think I see under the GDPR, when we interpret it, we heavily burden the data controllers rather than the parents. But I think there has to be some kind of more balanced way to approach this. If the parent is giving this access to the internet for their children, at least this shall be considered while maybe even defining the administrative fine or lowering it, or even for deciding to do unlawfulness or lawfulness of the processing. So coming back to your question, Celine, these are, yes, as Andy said, actually these are so-called free services. They're not really free. I consider these contracts that we conclude with platforms, with social network providers, as contracts, and they're in reciprocity, actually. So one party, even an adult, is promising to provide passively, most of the time, sometimes actively, to their data. And on the other hand, internet service provider, the social network provider, is actually giving the providing the service itself. So it's not for free, for sure. The idea of that being free is actually, I think, is already abandoned. But of course, they advertise it as free. So Coming back to the legal point of view, we have talked about consent and consent of children. On the other hand, we also have a contract concluded between the platforms and the child. So the child, in principle, is free to do whatever they want to do with their personal data if they have this discernment. But when it comes to concluding a contract, the situation is a little bit different in most of the continental law systems, because even if it looks like free, it's not free. So as a child, as an adult, I'm under an obligation to provide data to the other party. So this makes it a promissory transaction, actually. So a child cannot conclude it by themselves. They need the approval of their parents. So I think most of the time we see that social media, social network providers actually conclude that kind of contracts with adults and with minors, and in return of monitoring their behavior and sending personalized ads and providing the service itself. So this is held in reciprocity, and they are not really free. And it's also actually true when we talk about the consent of the child. It's most of the time very complicated, even for an adult, or we don't really bother ourselves to look into any privacy notices. We do think that they are dissimilar, and nobody really reads them. If we try to read them, I think maybe we have to spend maybe half of the day while reading them. So it's a little bit tricky, but this informed consent idea is already tricky. And when it comes to a child, it becomes more tricky, actually. The same is true for example, consumers. We try to inform consumers also about many situations, but consumers also don't read these notices and informations and so on. But of course, when a children's data is at stake, we have to take the best efforts to protect the child. So coming back, the contract and consent relationship, it's a little bit blurry because in these situations, when we conclude a contract with social network provider, most of the time it's not free, and the subject matter of this contract is actually consent to the processing of our data. So what happens if the consent is invalid, or what happens if the contract is invalid? So what happens if the legal representative, if the parents do not really approve the contract between the social media provider? Is the consent going to be invalid also? This is not really crystal clear, the answer to this question. It's also another issue that's debated. But I think my opinion, my position in this is to separate them, because their aim is completely different. Why do we seek the approval of the parents for a promissory contract? Because we don't want a child to start their adult life in debt. So this concern is less when it comes to the personal data, but still it's a promissory contract, so we still need to seek for the consent of the legal representative. But when we talk about the personality rights, such as the right on images, data protection rights, and so on, the law does not really look for capacity to act, like to be an adult in principle, to be 18 years old for the Turkish law. The law is looking into the discernment. So these two rights actually has been treated differently, at least in Turkish civil law legal systems. So I think we need to separate the validity of consent from the validity of contract, even if the consent is the subject matter of the contract. So a child can perfectly, I think, give consent to a social network provider their consent if they have the discernment for processing the personal data. But the contract cannot be valid if the legal representative does not approve this contract. But however, this is not the problem of personal data protection. This is the problem of contract law. So if we separate these two, we wouldn't be punishing the data controllers if the minor has a discernment, not seeking the consent of the legal representative, but just a contract not being valid and some unknown also consequences, because this is a contract concluded in reciprocity of data. So how do we really give back things? How do we really decide for the compensation is very, very difficult to assess. But at the end of the day, this would be the problem of the contract law, I think.
Yeah, actually, it's very interesting. Maybe US law is totally far away from the Turkish law. It's common law, and as Robert pointed out, the approach is different from its essence. They don't have a human rights approach. But for example, in a recent case, we saw US Federal Trade Commission filed a proposed settlement order very recently, a few months ago, in federal court in the children's privacy case, requiring the deletion of all information obtained as well as all algorithms. It's Weight Watchers, maybe some of you remember. It's about losing weight. So there's a system. So they were processing children's data, and as a result of the settlement, they ordered deletion of all information and algorithms, and they were required to update the procedures to ensure that they obtain verifiable consent before collecting information from children. So even in US, we see that kind of change, and we see that differentiation between maybe data being collected and as a result resulting in deletion of what was processed about children. There are more obviously examples in Europe, but also in Turkish example, in Turkish practice, we can see this differentiation between the consent and what process under the contractual terms, and whether we can go back if there was an unlawful processing, we can go back and request deletion of information. I think this can be an interesting example. And from a Turkish law perspective, also the Data Protection Authority has those kind of rights, so it is possible to also enforce. We see, as I mentioned, I mean, after the pandemic, we've been heavily using internet, and children have been exposed to online time more than before. We have some slides from Ofcom's reports, and it is really, very interesting to see the increase in use of times with age, and especially you see in the reports that children who are boys, especially between 15 and 16-year-old, half of them spend more than 6 hours a day online. I mean, they're obsessed with certain games. We know, I mean, my children are a little younger, but I know from my children, my friends' children, they socialize through those gaming platforms. And girls, they happen to have less time spent. Maybe they love gossiping and chatting, but I think gaming platforms became a way of socializing, especially for children around 15 and 16, and this becoming a bigger problem every day. We cannot change the fact that these are part of our lives now, and many parents are. I see many of them, they see it as a positive thing because children can now socialize even if they cannot get together. But we go back again. I mean, how we protect our children, given the circumstances with this much exposure to online content. And we will be maybe talking about also possible harms. But I would like to ask to Robert, what are the legal rights we can exercise as parents or as children under GDPR or UK's Data Protection Act to protect our rights?
Okay, good questions. I just thought it would be useful as I was listening to Nafia and Andy, that we've very much focused in the first hour and 20 minutes on online. And of course, you know, the topic is privacy in the digital age. And I thought it was worth just reminding us that data is collected about us and children, not just in the online environment. We go into a shopping mall or a shopping center, and there will be CCTV collecting our images as we walk around for not just our own protection, but also in some US malls where they're using smart advertising, the advert is actually recording your image and the time that you look at the advert and whether you then go to the shop to buy what you've just seen. That's digital. We are spending a lot more time now buying smart toys for children.
Yes.
And there have been plenty of examples again where the toy manufacturers have had absolutely no compliance in place over transparency about what's happening to the data and where it's being shared and how long it's stored and so on. So I just thought it was worth flagging up that you know, that the rights exist in the digital age, but not just in the online format. Yes, when you come to exercising your rights, again, the law is quite clear. When we look at GDPR, for example, or we look at the new proposals that President Biden announced within the last few weeks, that you have a right to stop your data being sold in the US, and that would apply to children. In the EU, we've got, if you are over the age that's been set, whether it's 13, 14, 15, you have rights to control your personal data as a 13-year-old, a 15-year-old, etc. And that is, you know, the right to object to automated decision-making or the use of algorithms, the right to have a copy of the personal data about you. Interestingly, if you are younger than the prescribed age, your parents may be able to exercise that right. But it's interesting that, again, we have to make sure that we are, the parents are both in agreement with what is being acquired. And we've certainly seen in the educational system in the UK that there will be, where a family may have, the parents have separated, there may be one parent asking for one thing, which is not actually because they're interested in the rights of the child, they're interested in where the child is in the company of the other partner, separated partners. So we're seeing a lot of education needed for those that care for children. you know, I'm thinking about within the school system, etc. But the rights are exercisable. One of the challenges that companies have when individuals exercise their rights is, again, identifying that that person is the individual that is entitled to exercise the rights. So we're back again to, you know, proof of identity and proof of age. And in the UK, where we've just been discussing, we don't tend to walk around with identity cards and so on. It does make the process for businesses that more problematic. Equally, if looking at this purely from a strict data protection point of view, if we are processing children's data as the controller, and you know, I'm using that definition under Turkish data protection law as well as under EU GDPR, the data might actually be in the possession not of the controller, but of the third party who is hosting the website or the analytics, etc. We need to prepare ourselves as a business for, again, preventing the worst from happening, or when the worst happens, having a mechanism to stop the crisis becoming a disaster. So to give you a practical example that involved toys, my client was American. They were what we call a fulfillment house, and their role was to send birthday cards to children whose parents had bought the children toys in a well-known toy shop. A great marketing idea. Presumably when the parents went to the checkout desk, the person on the desk said, "Oh, is this a special occasion?" And they might well say, "Yes, this is, you know, a birthday present for Salem, or a, you know, birthday present for Andy, etc." That got fed into the system, and birthday cards were being sent to these children for marketing purposes and good customer care, except that the database was not kept up to date. So my client was sending cards to dead children.
Oh.
And there was no contractual control in place. So when some of the parents rang my client to say, "Why are you sending birthday cards? You know, this is just so emotionally distressing." My client started apologizing on behalf of the toy store, therefore making the situation even worse. It so happens it was children's data. It could have been adults' birth dates, but the point is that the crisis did become a disaster, and it was massively brand damaging. So even if we legitimately have collected children's data, we have a massive responsibility for how we then manage it and how we ensure that we don't lose control of it or we share it inappropriately, etc. And there will be situations where the child is no longer a child and no longer needs parental consent, and then may say, you know, my mum and dad may have said this is okay. I don't agree, it's okay now. And I want my data erasing, or I want A, B, C, D, and E. And we're all learning, because looking at your graph, it's not surprising in the last few years that children are spending more and more time online. I wouldn't mind betting that the same report would show the same statistics for adults.
Yeah.
We're all doing the same. And I don't think we're ever going to reverse that. So I think that, you know, there are opportunities to be promoting more appropriate use by not just children, but the parents and adults of all the opportunities of the digital world. As I mentioned right at the start, Andy and I have been involved for many years with Southwest Grid for Learning, which originally started where we both live in the southwest of England or the UK. It started as a network of organizations helping schools to make better use of technology in the classroom, negotiate better discounts with, Microsoft or whomever. But then over the years, certainly for the Southwest Grid for Learning, our mission has changed so that we're doing far more to help schools with their own safety policies and their own practices. And indeed, I'm looking at notes from a presentation I did in March 2021, Andy, where I talked through a document called UK Schools Online Safety Policy and Practice Assessment 2020, annual analysis of the 360-degree self-review data.
That author was a great bloke.
Prepared by Professor Andy Phippen and Professor Emma Bond, no relation. So actually, we have Childline as a charity in the UK that enables children to report not just privacy concerns, but any harming mental, physical challenges. We have ChildNet, which is another charity that again works with children to help them teach other children how to manage their safety online. And then we have the UK Safer Internet Centre, which is part of the an EU initiative, so that there is a resource looking at internet safety, not just for children, but for all. So there's a lot of practical things that are being done, but there's an awful lot more that could be done. And just before I finish, I also printed off the other day a blog by our UK Information Commissioner, dated the 11th of April, where he was talking about being in Washington, DC in April to talk at an international conference about why more countries should work together. And his blog is entitled, "Why Protecting Children Online in the UK Living Room Starts 5,000 Miles Away." And he says, we started drafting our children's code, wanting to keep UK children safe, but we realized that it needs to be internationally received because the world is borderless and online services are accessed outside of your home country. This is why we're so pleased that California is now looking to introduce a children's code, and there's progress too in the Netherlands, Ireland, Sweden, Canada, and Australia. The more other countries require companies to protect children's data, the more children in the UK are protected. And you could apply that and say the same for Turkey. So there is a growing international recognition on this, and I'm delighted you say you regard the UK as leading the way, but I think globally this needs to be looked at more. Thank you.
Thank you. I mean, I think Southwest Grid example is a great example for all of us. I know for some foundations and charities also doing maybe similar or trying to do the similar work in Turkey, but again, UK is setting kind of a good example in these efforts in terms of regulatory, supervisory authorities, or charity side. And there is so much information available on the website of ICO or Ofcom's, like Ofcom's report, but also in the charities. And I know Andy would like to talk about a little bit of that as well. And then we can also maybe go into much of a detail on possible harms, subjects that you also have lots of studies and research. I would also like to hear from you, and I'm sure our audience also would like to hear from you, your research on those areas, and what can we do in terms of those harms, because also the reports we see, it's a growing concern for parents. So yeah, over to you, Andy.
I think the NGO sector in the UK has been very good at filling the gap between governments which are waggling the finger at companies and not doing much in the education sector, and the education sector going, please, we need some help. One of the things that Southwest Grid for Learning is currently winning a lot of awards for is something called Project Evolve, which basically provides a great deal of resources for schools in terms of delivering age-appropriate education around a great deal of topics. Because one thing that we know is that you shouldn't be delivering this in the computing classroom. It should be social education, sex and relationship education, those sorts of things as well. And I think the NGO sector in the UK has been very good at that. It's not entirely without criticism as a whole, though, because I think one of the challenges that we do face in the UK is that there is a great deal of money in this sector now, which attracts slightly less scrupulous people sometimes. And I'm always wary of people that go, we've got the solution to this, or we can stop this from happening. Those people worry me, because what we are talking about essentially is person-to-person interaction. And the thing I come back to again and again, and like I said already, is this model where we help mitigate risk. And that's a far better approach. I mean, again, to draw on the drug parallels, if you look at where progressive drugs education is going, it's going very much around harm reduction. So rather than saying, don't take drugs, kids, it's bad, and or if you smoke a joint, you'll definitely be taking heroin within 6 months, which is nonsense. You know, if you look at all of the drug science research, it says there's no causation. People who take heroin might have started off smoking marijuana, but someone's smoking a joint. But anyway, that's one thing we are very much lacking in this area. We generally respond to things not through an evidence base, but through, I'm uncomfortable with this, so I think we should stop children doing it. And I think that's where a lot of the political rhetoric is. And again, you want to get the public on side about something, say that children are going to be harmed if you do it. At the moment within the UK, we're having another debate about whether end-to-end encryption is a good thing or a bad thing. I can't believe we're still having conversations about whether end-to-end encryption is a good thing or a bad thing. Why is it considered to be a bad thing? Because child abusers might use it, not, you know, this is the means to, you know, it's all triggered off the back of Facebook saying they're going to bring end-to-end encryption into Facebook Messenger, and everyone goes, it's terrible. I know there are politicians groups on WhatsApp going, end-to-end encryption is terrible. You go, but all Facebook Messenger are doing is catching up with everybody else. And I think it seems to go in 5-year cycles. You know, age verification was being debated in 2017. It's being debated now, and I think one of the challenges we have is to do this from an evidence base, and looking at what harm reduction might look like in this area. If you're saying to a young person, "Don't share your passwords because it's bad," they'll go, "Why? And don't tell me what to do. I'm going to share my passwords." If you say instead, if this happens, this might happen, and as a result of that, this might happen.
I have a question here.
Yeah, go for it.
This is this is the most challenging thing for me, because when I discuss with my friends, they start asking me, what is the harm? Why you're so worried? There's no harm. And it's all
Absolutely.
about commercials, this and that. And even with my husband, it's the same thing. So I'm like, at some point I have no answer. And I can't prove the harm, possible harm, or the risk in maybe 5-10 years time for my child, not to use Fitbit, not the easy stuff, not to go online on certain platforms. So I think that's one of my biggest concerns. I can't explain, I can't really tell what can be the harm in a convincing way.
I think a lot of that, you can draw from like scenarios and stories in the media and similar. No one cares about sharing their passwords until they see a story about how someone was ripped off for 50 grand as a result of an online fraud, and then they're sat there going, that was disgraceful. What did the service provider do? There was a really famous story, I don't know if you remember, Robert, a few years ago, a child who was playing a free-to-download game, and he ramped up about 5 grand on his dad's credit card buying Smurf berries or something in this game. And the discussion in the media was, how have Apple allowed this? Not why has that father left his Apple account logged in with his credit card details there so the child can just go, I'll buy some more Smurf berries. I'll buy some more Smurf berries. When I'm talking to young people about password sharing and things, saying don't do it, it's bad is one thing. But when you start giving examples of how someone had access to someone else's cloud store because they were once in a relationship and then they split up, and as a result of that, then they accessed images of their new partner, and then they shared those images of their new partner with their peers, and then they ended up with a prosecution for image-based abuse. Those sorts of things generally make people sit up and take note, but this is the sort of thing that requires education to be delivered by people who know about this stuff.
Back again, the same subject.
Absolutely. I find it incredible that I will go into a school and I'll go, who's doing your lead stuff on this? Oh, this chap. Are they had any training? Well, they went on a 2-hour safeguarding course. It's like, well, what's their degree? Geography. Okay, so but they're teaching local. It's almost like, oh well, I use my phone, therefore I can do education around it. It's fine. And what you end up is people just bringing their own biases into classrooms and those sorts of situations. So
can I just jump in, Andy? Is that all right, Selin? I just
sure, please.
I've got a really good example of where we have to realize that when our children stop becoming children, they end up going into the workplace with all of the things that they've got wrong as a child. So I recently had a situation where a 18-year-old lady joined the employment team at a large company. Her job was, when applicants were being interviewed, she was required to scan a copy of the ID card of the applicant and proof of address into the system. She decided it was much easier to go down to the car park, have a cigarette whilst scanning on or photographing on her personal device the ID card and the utility bill. Nobody in the business realized that she was doing this for weeks and weeks and weeks and weeks and still hadn't put it back into the system. So of course, when you get an individual exercising their rights to know what personal data you've got about me, and I'm 18 years old as an applicant, the business doesn't even know that it's not even where it should be. And that's because probably there was nothing wrong in that young lady's eyes with doing that. So you've got these generations that will walk their way, sleepwalk their way into the business. Sorry for me jumping in there.
No, I mean, those sorts of things are a really good example. And that's one of the things I talk about a lot, particularly at university level. It's, can you do the talk to the computer science students, or can you do the talk to the lawyers? So there isn't a job in the world which doesn't have some requirement on critical thinking around the handling of data. The standard things that are just, we'll set up a WhatsApp group and talk about safeguarding issues about some children. You just simply can't do that. You go, oh, well, why can't you use your personal device? You know, all those sorts of things are so important. And it's just an absolute, because you have this belief that, oh, well, I use social media and I love sending people. I love group chats. Therefore, I am competent to judge the data protection risks and the safety risks and the cybersecurity risks. It's just nonsense. You know, there are so many times I visit a school that go, oh, well, we've given the the online safeguarding lead to one of the younger teachers because young people, they know about this stuff, don't they? I mean, I did start a talk to university staff a while ago by saying, if anyone says the word digital native, I'm going to throw a chair at you. Now, I wasn't actually going to do that, but there is almost this excuse, oh, well, you know, as if you've been born after a certain date, therefore you are genetically capable of doing this stuff. And we have generation upon generation upon generation of people who are doing this badly because we're still using the prohibited messages. So rather than, you know, saying, don't share your passwords because it's bad, explain, use scenarios, use examples. But I think the other important thing is to push back on the challenges of the harms that everybody talks about. I got myself into a little bit of trouble because I visited an NGO the other day and they've got a big banner up, harmful content. And one of the things they've listed as harmful content is pornography. And I'm like, is pornography harmful? I went, yes. Well, show me the evidence for that then. Because if pornography is harmful, why hasn't there been a huge increase in sexual crime in the last 20 years? Pornography is uncomfortable and unpleasant, and we don't like to talk about it because lots of people don't like it, but it exists as a business and lots of people consume it. So let's talk about harm from an evidence-based perspective. You know, we know that young people are approached by predators and predators engage in sexual discourse with them and similar. We know that young people come across upsetting content. But what we think the upsetting content, one of the most amusing things in the online safety bill is this talk about legal but harmful content. Like, who decides what the harm is? Or is that legal but icky content, or legal but, oh, I'd rather you didn't look at that content, and those sorts of things. There was a wonderful phrase in the draft which said harmful as considered by a person of ordinary sensibilities, which I'm disappointed to see has been removed from the next draft, because it's like, who the hell is that person? So let's instead look at from the evidence of it. Now, Salesforce for Learning has done a large survey of young people.
I have a also interesting question. We discussed about drug regulations, but I was going back to Robert's example of highway. And in order to drive a car, you need license. And for the license, you go through an exam, you go through an training or education, some kind of practical education, and then you have the license. So we know there's risks involved, not maybe, that when we look at it, the games and stuff, there are like tragic stories. So we know there's a risk. Should we somehow talking about, licenses for use of, I know it's a little bit too much, but at least, educating regularly through the platforms, or making that as an obligation for the users before they can enter to certain type of content. Would that be so crazy?
I know a cybersecurity professor that says that he thinks that people shouldn't be allowed to go online until they've done some sort of examination. He's a little bit sarcastic about it, but I can see where he's coming from with that. Yes, I mean this is one of the things. If you're saying something like don't smoke weed, and because it's illegal, great. If you say don't smoke weed because it might lead you to be paranoid, or you've done some education where they've talked to you about how your blood pressure might drop, so you might end up feeling very lightheaded, or you might pass out, because these are the things that, if you're having that level of education, then you're in a position where if something like that does happen, they won't just go, oh, I can't talk to, I don't know what's happening and I can't talk to anybody about this. And that's one of the things that young people talk about a great deal in this area. Just before I talk about that, the point I was making about the survey with Southwest for Learning, 13,000 young people, one of the questions The majority of these young people at primary age. One of the questions is, have you ever seen anything online that's upsetting? 30% say yes, they have. So the first headline we should take from that is 70% of children have never seen anything upsetting online. Isn't that a wonderful thing to do? But that doesn't shift newspapers. That doesn't get people going, oh, the internet's evil and terrible and bad, and the people that provide these platforms don't care about children. If you start to explore the sorts of things they talk about as upsetting, I've just done a breakdown for a colleague of mine because they're doing a school visit next week. So this school did this survey. The most prevalent disclosure around the upsetting content they've seen was all about the Ukraine-Russia war.
Mm.
When we had the Manchester bombing in the UK, they were talking about that. When we had the murder of Lee Rigby in the UK, they were talking about that. If we're talking about content that is harmful for children, and we're saying we need to stop children seeing it, then we're going to have to stop them watching the news.
Yeah.
But if instead you take a flip and go, right, okay, most of the time you're online, you'll be fine. If you see something upsetting, talk to somebody about it. You're not going to be in trouble. No one's going to go, oh, well, that's it, your life is over now. But instead, we want to provide an environment. Young people talk about this all the time. Sometimes I'll visit a school and they go, it's great, you can talk to a teacher about this and they'll help you. Other times I'll go, there's no way that I would disclose, say, for example, they sent a nude to somebody else. There's no way I'd ever disclose that to anyone else because I'd be told off. I'd be told I was stupid and they'd call the police. That's not the environment we want. We want an environment where young people are confident to disclose and confident that as a result of disclosing, something happens, which is where platforms could get a lot better. Because a lot of the, I'll give you an example. I was in a college a while ago. Said, we've got a problem. We've got a young man who's got 10,000 followers on TikTok, keeps on making jokes about having sex with children. There's about 50 students here who are getting really angry about it. We're worried it might spill over into physical violence. Right, first thing first, have you talked to this young man? Does he have a sexual interest in children? I said, no, we're fairly clear he doesn't. He just says he likes to do edgy jokes because that keeps his follower count up. I said, okay, so why haven't any of these students reported that account to TikTok? TikTok are quite conservative in their content. They would take that account down immediately. Both the staff and the student were like, oh, can we do that? You know, so if platforms were, which is one of the good things in the Online Safety Act, which no one's talking about, is the transparency reporting provisions they're putting in there, where companies have to show how many reports they've received, how they responded to them, how many accounts they've taken down from them. That's really powerful evidence to support the fact that when you do disclose, something will happen. And that's one thing that companies could do a lot better at, is showing that reports happen. The reports are responded to and things happen as a result of it. Now, myself and a few friends, we probably get about one racist a week taken down from Twitter because a number of us, have you seen this tweet? Let's all report the account. That sort of thing gets done. But if young people don't believe that the tools that are available are going to work, then they're not going to do it, which is one thing I think platforms could do far better at.
No, that's a very good point, actually. Nafia, I mean, I'm sure before we end today, you may add something to our discussions in terms of new, metaverse, new era of this metaverse world, how this can even complicate what we have been discussing, or the rules are rules and what we are discussing will be even applicable and meaningful in the upcoming years, even if we go through this big change of metaverse world.
The rules may, of course, change because the use of artificial intelligence in metaverse would probably make it more realizable, the breaches of personal data or personal rights. But at the essence, I think the issues would be the same, which is not yet solved even without the metaverse, as we see. So today, my suspicion is actually confirmed that there is no perfect law solving these matters. I completely agree with Andy that we need evidence for many things. We need more research, which is done maybe by psychologists or sociologists, because even setting the age limits on basis of what do you really set the age limit? In Germany, you pick 16, in England, you pick 13. Why there is a 3 years of difference between these two countries? Are there really local differences to create such a difference also? So like every rule that we bring is actually has to base on some kind of evidence, some kind of research. And I always felt that research is missing in Turkey particularly, but apparently worldwide the situation is not very different. So I think there isn't any ideal set of rules for the moment. When we look at the GDPR, its scope is very limited. Its scope is only related to information society services actually, and as Robert mentioned, the problem is not online only. It's when we say digital, it's more wide, and we don't really have a system of a fair share of responsibility between the stakeholders. So, but we have to define the stakeholders, and we have to, I think, have a bigger picture, a bigger solution accordingly. What I mean is that data controllers are not the only ones who should carry all the burden, but of course they should be, as my colleagues also mentioned, that they have to act ethically at first, and secondly, legally they should be bound with some obligations, but shouldn't be limitless really. The parents, the platforms, and also maybe the telecom operators. I think you have to look into this picture from a wider perspective, and when we regulate the area, not just like take the GDPR or data protection part in one sense, and then the harmful content in another sense. And it's very divided, and I think this makes it also very imbalanced.
Thank you. I think for today, my takeaway from our discussions is there are lots to do for all of us as parents, but also as NGOs and lawyers and regulators. But the answer is there. Rules are there. We just need to find the ways to more effectively use them to create more awareness, more communication between different stakeholders, even between children and parents. So that's where it all starts. We need to make children comfortable, protected, and safe. This is our duty because it is given to us as in terms of legal obligations, but also as parents. So in that sense, I think there are lots to do. I'm so thankful for your expertise and insights on the matter. This is a great present to the children for the Children's Day in Turkey. And I think that will be a good start for different initiatives in our country also to work harder in this matter, focusing on the discussions we had today. For our audience, please follow Robert and Andy for all this information. They have been working in the field for so many years. They are wonderful people. You already heard them talking very friendly, so very reachable, and experts in their areas. And Nafia, again, thank you so much for from a civil law perspective, giving this angle to us to actually focus and elaborate in days in common days to protect our children's rights and to do better in what we do and how we do it. So again, this was the 6th KP Talks. We will have the next one in May. We will be talking about AI, responsible AI, touching maybe similar aspects, and we have another amazing panel. We will be shortly sharing the information about the next one. Thank you again, and have a lovely day. See you soon.
Thank you.
Bye.